Everyday injustice. Too many wrongful convictions. Corruption has infected the criminal justice system, leaving too many people helpless, fighting for their lives. Instead of receiving justice, people suffer. Is that why they say justice is blind?
Today on Everyday Injustice, we have Rachel Barkow. She's a law professor at NYU, and it's been a few years since the last time we talked, but good to have you back.
Thank you for having me back.
So, we've had quite a bit happen in the last few months, but I've been wanting to talk to you a little bit about the commutations from former President Biden, although it feels like it's been 100 years since he was president. But I do think it's important stuff. He did kind of this interesting thing, right? He did almost nothing, and then he commuted a whole bunch of people, some of whom were already out, some of whom were on nonviolent drug offenses. Perhaps the biggest thing that he did was the 37 commutations of death row incarcerees who were then sent back to life. And he finally released Leonard Peltier, who I've been reading about since I was in high school. So it's quite the gamut. But would you say that he ultimately, exceeded your expectations, or do you feel like there was still too much left behind?
Oh, that's a tough one to answer because, to be perfectly honest with you, I had very low expectations. And the reason I had low expectations from the beginning is I never fully believed him when he made pledges about criminal justice reform. I felt like they were opportunistic statements to just try to gather some additional votes in order to win the nomination. And unfortunately, that I think did prove to be correct. He did not do very much on the criminal justice front during his presidency. And although I can't fault him for not getting more done with Congress, that's a whole different ballgame. Plenty of us told him from the beginning that clemency is one of these spaces where you have a lot of authority on your own to do good things. And he ignored it up until, this flurry in the last month or so. And the problem with when you wait that long to turn to the clemency power is you inevitably leave too many people behind. That is just the product of not fixing the process, which we begged him to do, and which he promised to do as part of the Biden-Sanders task force. They said they would take clemency out of the Department of Justice and create a better process. Because, when it's in the Department of Justice, your clemency petition goes before the pardon attorney's office. They ask the U.S. attorney that prosecuted you, what do you think? And, it's a lot to ask cognitively of somebody to say, hey, that prosecution you brought, were you wrong? So they usually recommend denials. And so it's very hard to get through the DOJ review process. And lots of us had said, hey, move it out. And he didn't do that. And worse than that is we actually did have a good pardon attorney. We kind of got lucky this time around where we had a good pardon attorney, and I think the deputy attorney general and the Department of Justice were actually more willing to issue positive recommendations than in many years past. So although I still think there were too few, they actually did recommend a ton, and those petitions were sent over to the White House. And, I just read this weekend in the Wall Street Journal, so it's public information, that the pardon attorney sent an email to U.S. attorneys around the country saying there were hundreds of petitions with positive recommendations that went ignored. And to me, that's inexcusable. I just don't see how a president can have their Department of Justice, which goes through a really intense vetting process, where if you get a positive recommendation from the Department of Justice, that should be the easiest grant in the world. But they left all those people behind. So to me, that's inexcusable. And it's hard for me to come to terms with that, even though at the same time, I am grateful for all the categories that he did grant. That is such a big gaping hole that I don't know how you can live with yourself as a president if you don't get to those. And then in terms of his categorical grants, there were flaws there too. I'm a big believer in clemency, but I do think that if you're going to do like a big categorical grant, like he did with the quote unquote nonviolent drug offender category, you got to be competent at it. And, they weren't. There's a lot of people in that group that got grants where in that same email that the pardon attorney sent, she said, we would have never recommended those grants. There's some people with some really serious records in there. And so I don't know how you justify kind of a block grant that includes those kinds of things, but you don't grant the people who went through the whole process and the vetting, and you ignore them. So for me, I had low expectations. They were met. In some ways, he surprised me in a positive way. I was very pleased that he did the death row commutations. I thought that took courage. That one I give him a 37 out of 40. I thought he should have granted them all. But I appreciate that he granted as many as he did. But overall, I thought that was disappointing. And we haven't even started talking about the grants that he gave to his own family members, which, raises a whole separate set of issues.
Yeah, I wasn't even going to get into that just because that becomes a political quagmire, and I have problems with that. I'm, I like that he did most of the death row people. I don't like that he didn't do them all because it basically says, well, the death row is valid in some cases, and yeah, okay, we know those three people, right? So it's not like they were gray areas, and I get, I'll grant that part, but come on, either the death penalty is immoral and outdated and ineffective, or it isn't. And if you go 37 out of 40, as you put it, you're not doing that.
Yeah, I would have preferred a more principled stance as well. That was a statement about, look, we're just never going to trust the government to make the decision of who lives and dies as a consequence of criminal behavior. Like the government is inept in so many ways, and why would you ever trust them with a life and death decision? And when you do 37 out of 40, you're still saying, yeah, we trust the government. But in general, I don't think we should. I mean, there's so many racial disparities. There's so many instances where it's not what I think anyone would think of as the worst of the worst. Sometimes it is, and like you said, those three cases. I'm not like shedding a tear. I'm going to be honest. I though that, but it's a principle, and I think it would have been better for him to have made the decision on a principled basis. Because I think that has a better historical legacy going forward. I think when you use the clemency power, you obviously have your immediate beneficiaries who are obviously grateful for what you've done, but you're also sending an expressive message about, what do we stand for as a society? When should this power be used? And I think he muddled the message a little more on the death penalty than I would have liked. I think if you do all of them, you're sending a really strong signal for history that says, I do not believe the state should ever do this. And instead, the message was, I think we should use it in only rare circumstances. But, as soon as you say rare circumstances, that exceptional kind of notion ends up swallowing the rule, and you end up right back with 40 more people on death row in another administration. So I I was grateful for it. I don't like to sound ungrateful because I gave a hoot and a holler the morning I saw it when I woke up. I was very, very grateful. But
Well, let's be honest. I mean, he saved people's lives with that.
exactly. And, it's hard not to be moved by that. It really, and there were a lot of people who worked very hard on that. And I think the Vatican, I think, was very influential on that. And so, it's all to the good. And I guess, it's something to build on in the future, I hope.
And it will be instructive now. I live in California, as you're aware. And so the question is, what does Governor Newsom do? He's termed out at the end of next year. He's put a moratorium on the death penalty. They've cleared out death row. But technically, those sentences could be activated in the future. And so everybody's kind of wondering, is Newsom going to actually do it? And he doesn't quite get the freebies that Biden does. Like, Biden was never going back into office. I think Newsom still harbors delusions that he's going to run for president. And also in California, the courts can revisit the clemency, whereas in the federal government, it really is absolute power by the president. Any thoughts on that? I don't know if you've looked into it.
No, I agree with you. I think the situation that Governor Newsom in is different because he is not at the end of a political career. He's just at the end of a governorship, and that's a very different scenario than Joe Biden. I mean, that's one of the reasons why I didn't think it was outrageous to ask Joe Biden to commute all of federal death row. I mean, in a normal circumstance where you have someone kind of younger and with a full political career ahead of them, you can make the ask, but I think you realistically don't ever expect it to happen. And I think we were in a unique situation with Joe Biden that allowed that to happen. I don't think that that's true of Governor Newsom. I think, if he's thinking of national political aspirations, he's trying to shake the image that he's a West Coast liberal. And the last thing somebody who's trying to shake an image like that probably wants to do is commute sentences of people who did really, really horrible things. The political ads just write themselves. So I totally, I think I wouldn't bet on it. You never know. I mean, maybe he will come to a different calculus about what his political future is, and what what it would take to take the next step, whatever it is that he wants. But if past is prologue, usually people in situations like his try to go to the center more and appeal to a broader populace than California voters.
Yeah, so shifting gears a little bit, the last time we met, you were talking about your previous book, Prisoners of Politics, which I still find one of my favorites on the
Thank you.
subject. And the subtitle, Breaking the Cycle of Mass Incarceration. And it's kind of interesting, kind of historically situating that book as kind of the high water mark of criminal justice reform. And now we've kind of seen, maybe the nadir, maybe, things rolling backwards, certainly out here in California. As I mentioned earlier, I just interviewed Chesa Boudin, who, of course, was the progressive prosecutor in San Francisco who was recalled. And then across the bay in Alameda County, Pamela Price was just recalled last election. And down in LA, you had George Gascon who lost re-election. And so you've kind of seen this rollback of criminal justice. And here in California, we rolled back Prop 47 a little bit. And we couldn't even pass a Prop 6, which would have ended slavery in prisons, which I think is the most absurd thing I've ever seen because there was no organized opposition and it still lost. So kind of, and we'll talk about your new book in a minute, but kind of, share with us kind of where you were in 2019 when that book came out versus now.
Yeah. So, actually in 2019, I did warn people that the politics of criminal justice wasn't as rosy as people were thinking it was. And, 2019, people were feeling good about a lot of reforms. And the book really goes through some of the pathologies of popular political elections over things that suggest we're never really going to get that far with our given structures. And I was very cautious, and that's why I focused on what I thought the kind of key places for reform would be, which were trying to insulate some decisions, use the political momentum to try to insulate some decisions from direct popular appeal and reversal, and think about ways to win in the courts. And in terms of the progressive prosecutor movement, one of the things I warned about in the book was that, there was like a head start for the progressive prosecutor movement where the people who saw an opening to challenge incumbents, I mean, it's very brilliant politics to kind of say, hey, look, we could start winning these offices. And it was great, but it was obvious to me and lots of other people that that was going to last forever because the other side was going to mobilize in response. We were kind of seeing in 2019 when I wrote the book the first wave, but we hadn't yet seen the backlash. But it was obvious the backlash was coming, and so I and other people had said, look, if you're a newly elected progressive prosecutor, you need to be seeking institutional reforms that will outlast you, because if all you do is say, when I'm a prosecutor, I'm going to exercise my discretion in all these great, wonderful ways, that's all well and good till you lose the office. And then the next person comes in and they just do something different. And so, one of the things I argued in the book was use your political capital to try to get mandatory minimums repealed. Do some things to take away some of your office's jurisdiction. And then that's much harder to overturn, because then you need legislative actions to overturn it. So I was never one of the optimists. I never am, really. But I wasn't in 2019. And that was actually one of the criticisms I got when I wrote the book, was like, oh my gosh, you're totally missing what's happening here. There is a revolution. And in 2020, it certainly looked like the people who said that to me looked right. We were riding the George Floyd protest wave to what looked like a real transformation in policing and prosecution. And I even for a little bit there thought, gosh, maybe I was unduly pessimistic. Maybe I didn't read the generational shifts right, or what video cameras that show the public things the police do could transform society. Maybe I underestimated all that, but unfortunately, I think the book holds up, and I think it holds up because those political dynamics are really embedded. And unless we have a very big cultural shift, which the George Floyd movement was like so close, but unless we have a big cultural shift like that, I think those political dynamics are they're very strong, they're very stable, and they're very hard to overcome.
And I mentioned this to Chesa when we talked earlier, that I was out at a Black Lives Matter protest, and I saw people there that I would have never in my life expected to see at a protest. And they had the signs and they were there. And I kept thinking in the back of my mind, okay, is this really, the turning point, or how long does this last? And of course, it didn't last very long from there.
No, no, it's a shame. But I mean, I do like to think that there was still an educational value to everything that happened, and I don't think that that completely went away. I do think you have a much larger segment of the public now that is aware of police excessive force, and has a much better and greater sensitivity to the racial discrimination in policing. I think that's true. I definitely believe that there has been a shift in public attitude. But I think the reform community pushed that way further, than where the public felt like, to admit that, but then go with, so let's get rid of the police altogether. That's when you start to scare people too much, and you lose them. But I don't think it necessarily means that you lose them for more modest reforms, or that they're not going to be willing to support things in the future. I mean, unfortunately, we haven't seen our last horrible video. That clearly more bad things are going to happen, and I think there's still going to be plenty of opportunities to mobilize people to do good things. I think that it would be a good idea, though, for people to maintain some strategic realism. And I get it. It's this is when I feel just very old, because I teach younger people, and they say, oh, you just don't know what's possible to imagine. And I think I totally get you, but at the same time, you got to poll test some of the things you're talking about, because you lose a lot of the voting public when you push the envelope too far. And I just think that that's what happened. And it's a shame. But I don't think that all the gains are lost. I think there were still some good things that happened around the country. I think there were some good reforms that passed, and hopefully those reforms will make the case for future ones as we move forward.
And I agree with that. One thing I like to talk about is I feel like the floor of criminal justice reform has moved a lot, in the last decade and a half since I've been in this space. what hasn't moved as much or maybe has receded is kind of that leading edge. But, you see people that are, in my view, conservative who still understand that we can't mass incarcerate ourselves out of a crime problem, that the answer isn't always to throw more people in prison. And, as horrible as the DA in LA has been, he hired a pretty reputable guy to do police oversight and things like that. And so there have been changes that are real, and I think they're going to stay. The space where we're at, I get a little nervous on some of the stuff, but I'm curious because like here in California, it feels like the end is coming. The end is coming. We saw good people lose, even relatively moderate people like the DA in San Joaquin County, where Stockton is. She was a Republican and she was in favor of reform, and she still lost her election. But it looks like you're in Manhattan at NYU. Alvin Bragg seems to have maybe some staying power. He's not facing the same problems that we saw with George Gascon or Pamela Price or Chesa Boudin. Is that impression accurate in your sense?
Yeah. I think the impression I would take away, or the overarching idea is, these are local elections and they very much depend on local political dynamics. So, Chesa, unfortunately, found himself with a gazillion dollars being lined up against him and trying to hold him responsible for things like unhoused people, which is just not the the district attorney can only do so much. And I think people blamed him for things that weren't really things that you should associate with the district attorney. And I think he also, the groups that supported him, San Francisco is just a different city than some of the places where reform prosecutors have been reelected. So, for example, if you compare the demographics of San Francisco with Philadelphia, where Larry Krasner was reelected, there's a much larger Black community in Philadelphia than there is in San Francisco, and they are great at making sure that they mobilize voters and people understand the problems of policing for Black community members. That is a constituency that I think is very important for the reelection of some of these progressive prosecutors. And San Francisco is a less diverse place when it comes to having a large percentage of the population being Black. And I think that, for example, is an important factor when you analyze what happened to Chase. So you can kind of, I guess that's what I would just say is like place by place, you want to say, okay, who are the people that are going to come out in support of this prosecutor? Are they going to get out the voters? Are they going to, because typically a district attorney election is pretty low turnout affair. And so, you're really thinking about who's mobilizing voters and how is it all going to pan out. And sometimes it depends on big cases that just take an outsized role in making the voters just care about particular cases a lot. So, for Alvin Bragg, it's the Trump prosecution may end up being, just a really important thing for him. So I think the bottom line is you can be a progressive or whatever you want to call these decarceral, reform-minded. There's different labels people like to use for them, but not the traditional tough on crime. I'm just going to come in there and be as severe as possible. We're seeing people like that win elections and re-elections all around the country. Are they also losing? Yes. And I think all of that is just a byproduct of the fact that every one of these jurisdictions is a little bit different. And you have to be really attuned to the local politics to figure out what it takes to win. And that's what I meant when I said that progressive prosecutor movement had a first mover advantage, because when they initially did it, they caught the other side off guard. I mean, they really did.
Yeah,
And that
I
just
agree.
doesn't happen anymore. Like everybody knows now, okay, these are going to be contested. We're going to have to fight for every vote. We're going to really have to think about how you appeal to voters across a range of the population. And so they're going to look different than they did the first time around, but they're still winnable, I believe. And it's just going to take more effort, and probably more attention to what a particular local community cares about and wants.
Yeah, and what you might end up seeing is that the progressive prosecutor is going to be somebody from a DA's background who is a little bit more progressive rather than a public defender who takes over. Because it seemed like that that scared a lot of people.
Yeah, no, I mean, that's a much bigger hill to climb. Although, George Cascone had a long law enforcement background, and he still couldn't overcome.
Yeah,
Yeah, so it's still not perfect, but I agree with you. I think you're right that you want to kind of make the public feel as comfortable as possible that the person running cares about public safety. I mean, and the messaging is just it's like you want to tell the public, of course we want public safety. I want that too. I'm just telling you there's a different way to achieve it that's actually better than this strategy that we've adopted where we try to incarcerate everyone in our community for excessive sentence lengths and put them in pretrial detention and make them lose their jobs. Like, it's a way of trying to educate people about the counterproductive things we do if what we want is public safety. And I think you're right that the best messenger for something like that is someone who has spent a long career in law enforcement and can say, look, I've dedicated my life to public safety, and I believe there's a role sometimes for imprisonment, and I've done that, but I've also seen that we overdo it in ways that backfire. That's a good messenger, I think, to get people to start getting used to the idea that there's actually better ways to deal with these problems.
and then in the last segment, I want to talk about your upcoming book, which looks like it's coming out in exactly 4 weeks from the time of this recording.
Yeah.
And so I look forward to reading that. It's called Justice Abandoned: How the Supreme Court Ignored the Constitution and Enabled Mass Incarceration. And so I'm kind of wondering, as I read the teaser here, in Justice Abandoned, Rachel Barkow highlights 6 Supreme Court decisions that paved the way for mass incarceration. So let me just ask this kind of weird question. Is are these 6 cases going to be like, oh yeah, okay, yeah, or are they going to be like, oh wow, okay, I didn't think of that?
Well, I think it's a mix. And I should just tell you the criteria. I have more than 6 Supreme Court cases that I don't like, that I think have been bad for criminal
Of
justice,
course.
in case anybody is wondering. But the ones that I picked were because I think they cannot be justified under any of the traditional theories of constitutional interpretation. And in particular, even if you were an originalist, one of the people on the Supreme Court who believes we should look at the Constitution based on the meaning that the framing generation gave it, what's really interesting about these 6 cases is they fail that test. I mean, the history is quite stark. And so for me, I think when you can have a case that you say, look, the text of the Constitution doesn't support this, the original meaning, if you took the framing generation, they'd have never done this. And subsequent history, we never did this until this case, until the point at which the court kind of jumped ship. So that's why I picked those. And I think there are some surprises in the sense that I think the public, people who aren't kind of reading cases and history all the time, might be surprised by things like we did not detain people because they were dangerous or perceived to be dangerous after committing a crime. We never did that until the Nixon administration came on the scene and had a concerted plan to change the law. I mean, they orchestrated that. They did a remarkably good job at it, and then ultimately got the Supreme Court to shift course. But absolutely, that is unconstitutional if you believe in original meaning and the history of, due process, the Eighth Amendment, and the presumption of innocence. Like, you just can't detain somebody because you're accusing them of a crime and you claim that that makes them dangerous. There's civil commitment, there's ways you can get people who are dangerous to themselves and others, but the idea that all you have to do is charge them with a crime and then you lock them up in a jail because you say, oh, that crime, that suggests they're dangerous, without proving them guilty first, unheard of. And so I think that's the kind of thing that maybe would be a surprise to people. And then to just find out the kind of weird way that that gets upheld, because the Nixon administration decides to do this first in the District of Columbia, and they have a bunch of lawyers write a bill for DC that include Chief Justice, later Chief Justice Rehnquist, but then lawyer for Nixon, Rehnquist, writes the DC legislation. And then after they get something passed in DC, they then make a federal version that's way worse, that allows the detention of people, that on a presumption of dangerousness if you commit certain drug offenses. I mean, it's bonkers. So that's the Federal Bail Reform Act that passes in 1984, and it goes before the court in this case called Salerno. So, that's my first chapter. That's the first one. And who decides that case, writes the opinion? Rehnquist. So here he is now. He's on the court.
So how's that not a conflict of interest?
It's even worse than that, because the case should have been deemed moot anyways, because the two people who challenged it, they're really entertaining mob figures, actually. One of them had already been convicted and sentenced, so he wasn't really being detained pre-trial anymore. And the other one, the government let out because they had signed him up as a cooperator. So he was working cases with them. So that case should have never even been on the docket. And it's written by the guy that wrote the DC legislation. So, each chapter kind of there's, I hope, interesting stories like that in each chapter. But the main point is to show, after the court accepts something that had never been accepted before, what happens next? And what happens with pretrial detention is we get 500,000 people who are incarcerated in America. Almost 500,000 are there pre-trial. They haven't been convicted of anything. That's more than the incarcerated population of most countries around the world. Like, that's an enormous number of people. And in America, they're being detained without first having been found guilty, and it's because of what the court said. And so what I'm trying to do in the book is explain that although I believe it's political impulses that want and get mass incarceration to flourish, there's this other side of the story, which is the Supreme Court should have been there putting a brake on some of this stuff. And they didn't live up to their responsibility. And so, the cases are mixed. We have plea bargaining, prison conditions, excessive sentences, police stops, Terry stops, and race discrimination. So those are my 6. And I hope people end up liking it. I wrote it. It really is the kind of sequel to the first book, because when I was working on that and saying, what do you do if you can't rely on politics? Where else can you go? And in America, we do have a constitution, and you can go to the courts. And so it was a look at why that failed us.
Yeah. And I've read book after book about the failures of the court to back up rights, and I'm assuming Terry v. Ohio is one of them.
Yes, you got it. Yeah.
I mean, one of the interesting things, I was just reading this book on Miranda and the actual background case, and I had never really read it. And there were a couple of interesting things. First of all, the guy Miranda, not a good guy. And a lot of these guys that end up, kind of being these seminal figures are not good guys. I mean, this was a rape case. And, the thing that was kind of most appalling is that they went through the whole rape investigation, and every single thing that they did wrong to this woman who was a victim, they disbelieved her, and they put her under a polygraph. And I mean, it's like how not to do a rape investigation, and somehow they accidentally end up catching the guy, not because of any police work, but because a friend of hers happened to grab enough of the license plate when the guy was circling around the neighborhood, that they were able to kind of connect the dots. Otherwise, this rape person would have probably gotten off. And that was Miranda. And then, of course, they railroad him into a confession. And the other really interesting thing is, evidently this happened in Phoenix, Arizona, and the county attorney, who's the prosecutor in Arizona, figured out before anything happened that this was not a good interrogation. And so they actually put forward rules on how to properly interrogate and advise people of rights. So they knew that this was a problem case even before it got to the court.
That's super interesting. I mean, the one thing that I always think is interesting about, so I think people that think about the Supreme Court think about Miranda and Mapp versus Ohio, which is the case that excludes evidence that had been obtained with unconstitutional searches. I think those are the cases that people associate with the Warren Court, and they think, oh, I mean, there was this court and they cared about people's rights, and they passed these landmark decisions. And I think what some lay people may not realize is the backlash to that, in the 1968 presidential election, which is the year that Terry is decided. I mean, the Terry chapter, I think, is for me was super interesting because it made me dig into, what was going on in 1968 in America and kind of set the stage for Terry getting to the Supreme Court. And there are signs on people's lawns that say impeach Earl Warren.
Yes.
And Nixon is running basically against the Supreme Court. And the Supreme Court knows this, right? They know that those decisions were hugely unpopular, that there's editorials and papers around the country when the Terry case comes up, basically saying like, is the court going to blow it again kind of a thing. And when Terry is decided, DC is burning. There are riots, and there's actually, I talked to a clerk from the time the decision was being argued who said, we were looking out the court windows, we could see smoke. And so, you kind of think to yourself, okay, in 1968, the Supreme Court is thinking, look, we did Miranda, we did Mapp, but this is bonkers we can't do it with Terry. We got to find a way to let cops, if they're telling us they have to stop people, even though they don't have, the constitutional reasonable suspicion, we're going to just create this new standard because I think they were scared. And there's notes from the justices' papers that suggest that they were trying to kind of find a way. So, so this is not Terry versus Ohio is not the product of some original meaning, this is the text, this is how we do constitutionalism. It really is the product of we don't have the political capital for another Miranda. And we absolutely can't deliver a decision like that. And I think the court just made the call that they were going to come out in favor of the police, even though, they also had briefing in the case that said, do you know how bad this is for communities of color? Like what the police are doing in these communities when they are stopping people like this will be terrible for police community relations. So the court knew full well, but still went ahead and did what they did in Terry. And I think it's important for people to recognize that there is a flip side to things like Miranda and Mapp, which is when the backlash came, the court capitulated. And then once Nixon wins, he appoints people to that court that change it forever.
Right.
That is like the end of the Supreme Court being a source for really major criminal justice reform after that. They're few and far between the protections that come out of the court after that. So it's, to me, I think lots of people know this. It maybe will be a familiar story for plenty of people, but I think there's definitely a pretty big segment of the population out there that doesn't really realize that even the Warren Court blinked, and they did so in a case that had really unfortunate.
And they did it intentionally. Yeah. Like if you read the accounts of some of the justices that worked on that, they knew what they were doing.
Yes.
And they felt, and this is kind of what I was going to ask you about, is they felt like if they didn't come down with that there was going to be something worse than Terry. In retrospect,
I think that's right.
What do you think of that?
I mean, I think so I have a very traditional view when it comes to the Constitution, which is that you go with it. Even if you think, and I think that's what it's for. Like it's to try to bind us to important long-term values, even when in the short term we get really scared. Like it's not much of a constitution if every time you're scared of something, you say, oh, okay, let's just not recognize the right now because it's too scary to do it. Like then it's not worth the paper it's printed on. It is a document for the long haul. And that's why those rights are in there. And you can't be so afraid of public safety issues that you give the police unfettered authority to do things without protections for individual rights. I mean, the framing generation, I mean, this is one thing I also think is very interesting. Originalists on the bench tend to focus on the causes that conservatives care a lot about. So they property rights and outlawing abortion and not recognizing certain progressive rights and values. But actually, if you are a non-hypocritical originalist, you should be up in arms about some of these criminal justice decisions because they completely flout what the framers had in mind. They were really worried about excess governance for criminal enforcement. Like it's all over the Constitution, it's all over what they did. And so for me, for the court in Terry to say, oh no, we have to give the police this weapon because otherwise what will happen to public safety, or there may be pushback and, maybe people will try to do something worse. Like, I just don't think that's the court's job. They have one job and it's to interpret the Constitution and to do it faithfully. And then after they do that, we have to see what happens after that. And I think when they try to broker deals or they try to soft pedal, I think history shows that that's always worse. And I think that's what it showed with Terry.
And the most interesting thing, I think, to me is how narrow a window we're looking at. Because if you think about it, Earl Warren's on the court in 54. He's off the court by 69. And other than that brief sliver of time, the court has been a force of regressivism rather than progressivism.
Yeah, for the most part, I think that's right. I mean, I think they lag behind, they typically lag behind public opinion as it moves in more progressive directions. Although, I do think it can shore it up nationally in a way that would never happen if you let it proceed state by state. So I do think the court plays an important role. In terms of having kind of national minimum standards for things, but it's a very cautious institution, and as you say, it's often a regressive one. And for me, I think it's just important to point out that, I think it's fine for somebody to be an originalist and say they want to do what the framers, they're going to go by the original meaning, and if that's your theory of interpretation and you've justified it, I think that's fine, but you have to be consistent. Like you can't just be an originalist sometimes when it supports a conservative outcome you like. And so one of the things I hope to do with this book is point out, look for their votes in these cases as they come up, as people start to raise these issues. If you are a true originalist, you just can't sign on to Terry versus Ohio. You can't. You can't sign on to pretrial detention on the basis of dangerousness. You can't. Now, you could say, "Oh, I wouldn't have decided this in the first place," but once the court did, I'm going to keep it. But then explain Dobbs, because once you say you're going to overturn a 50-year-old precedent like Roe, because if the case was wrongly decided, even if it's 50 years old, okay, then that's Terry, that's Salerno. So to me, it's important, I think, to just at least get it out there in the open that there is this area of doctrine that originalists, people who care about criminal justice, it's obviously not just originalists, but, anyone who cares about these issues from an equality standpoint, from a rights standpoint, these are just terrible cases. And, it felt good to write the book, I will admit. I felt like I got to vent some cases that have bothered me for a really
I'm not
long
sure
time.
I'm going to feel the same when I read it, but I do look
Yeah.
forward to reading it.
Yeah, I hope people enjoy it. And honestly, I hope advocates take up the charge. I really do. I hope it at least gets people to think, like, do not accept some of these things as having been written in stone from America's founding. To the contrary, they're pretty new, they're pretty terrible, and they can be overturned, they can be limited, they can be overdone by legislation. There's a lot of ways that we could try to get rid of some of these things. And I hope the first step is recognizing what kind of outlier positions they were in the first place.
Well, we'll leave it there. We've been talking with Professor Rachel Barkow from NYU. Her new book's coming out in a month, Justice Abandoned: How the Supreme Court Ignored the Constitution and Enabled Mass Incarceration. It's on my list to buy when it comes out, so I look forward to it. If you want to send me a preview signed, I'd love it. I'll put it next to your other book. But this has been Everyday Injustice. I'm your host, David Greenwald. Join us again next time for more tales from the injustice system.
Thank you to George Powell and Norman Mouse Quake Barrett for the use of our opening, Everyday Injustice. You can see more of George's music at www.justiceforgeorgepowell.com. That's Justice for George Powell, all one word, .com.